Welcome to an in-depth exploration of the Indian legal system. Today, we examine a powerful yet highly debated mechanism, judicial activism. The Indian judiciary faces a continuous balancing act between fulfilling its constitutional mandate of proactive justice and avoiding institutional overreach. Let's look at the baseline matrix of this institutional impact. On the positive side, proactive judicial intervention ensures enhanced rights protection, fills critical policy gaps, and has institutionalized public interest litigation. However, when this boundary stretches too far, it triggers systemic overstep. This can cause the erosion of the separation of powers, introduce policy uncertainty, increase the judicial case backlog, and create intense friction between the executive and the legislature. To understand how we got here, we must look at how the rules of access changed. Traditionally, the Indian legal system operated under a strict doctrine of locus standi, or traditional restraint. Under this rule, a strict barrier existed. Only the directly aggrieved person could approach the court for justice. If a marginalized group couldn't access a lawyer, their grievances remained unheard. But then came the activist shift, driven by proactive cognizance. The courts opened a wide funnel of accessible justice. Today, multi-input avenues bypass traditional bureaucratic red tape. Now, ordinary citizens, investigative media reports, and non-governmental organizations can directly demand rights for the marginalized, fundamentally changing who the court protects. The defining turning point of this shift occurred in 1979 with the birth of Public Interest Litigation, or PIL. This radical movement was initiated by visionary, proactive jurists like Justices P. N. Bhagwati and V. R. Krishnaiah. The true catalyst was advocate Pushpa Kapila Hingorani, widely revered as the mother of PIL. She filed a historic habeas corpus petition in the landmark Hussainara Khatoon v. State of Bihar case, securing the release of thousands of forgotten under-trial prisoners. The core mechanism was simple yet revolutionary. The Supreme Court began relaxing rigid legal formalities, choosing to admit mere postcards and newspaper reports as formal constitutional petitions in the public interest. The era of judicial passivity was officially over. What gives the judiciary the legal authority to act so boldly? The power rests on three structural pillars within the Constitution of India. First is constitutional interpretation. Over the decades, the courts expanded the scope of fundamental rights, notably elevating Article 21 from a strict interpretation of procedure established by law to the broader, fairer standard of due process of law. Second is judicial review, the inherent constitutional power to review and declare arbitrary actions committed by the legislature or executive void. Third, and most potent, is Article 142, which grants the Supreme Court the unique power to pass orders to ensure complete justice. While intended to fill equity gaps, it allows the court to temporarily take on executive and legislative functions. This was aggressively utilized in the 1989 Union Carbide case, where the court stepped beyond standard statutory frameworks to secure a final settlement for the Bhopal gas tragedy victims. To analyze this power, we must distinguish between constructive activism and harmful adventurism. Under positive judicial activism, the primary objective is to deliver speedy justice, protect vulnerable sections of society, and uphold core constitutional values. Its mechanism relies on admitting legitimate PILs and progressively expanding fundamental rights. Its democratic impact is highly beneficial. It fills governance vacuums and restores public faith in democracy as a last resort. Conversely, negative judicial overreach occurs when the court's objective shifts to assuming the daily administrative responsibilities of elected lawmakers. Its mechanism involves issuing direct civic directives outside judicial expertise or rewriting clear constitutional texts. This impacts democracy negatively by violating the separation of powers and transferring real policy-making authority into the hands of unelected judges. Let's first look at the positive side, how activism effectively fills a governance vacuum. When legislative apathy or executive indifference leaves the public unprotected, the judiciary acts decisively to protect citizens. Furthermore, the judiciary acts as a vital check against autocracy. Through the basic structure doctrine, the courts can prevent a ruling majority from passing arbitrary constitutional amendments that undermine democratic foundations. For millions, the court serves as the ultimate custodian of the Constitution, the last hope for restoring a marginalized citizen's faith in democratic processes. This proactive stance has driven real, tangible social progress across four critical sectors. Social equity: the court has championed marginalized communities, notably through the decriminalization of Section 377 and banning instantaneous triple talaq, talaq-e-biddat. Fundamental rights: it progressively elevated the right to privacy to an intrinsic, protected fundamental right under Article 21. Democratic transparency: the court cleaned up the electoral process by mandating that political candidates make strict, transparent criminal and financial public disclosures. Ecological survival: through sweeping, proactive environmental interventions, the judiciary has consistently stepped in to protect ecosystems against unchecked, hazardous industrialization. However, there is a distinct tipping point where positive activism turns into interference. Constructive activism morphs into negative judicial adventurism the moment the judiciary oversteps the separation of powers, which is a basic structure of our Constitution. When unelected judges begin dictating policy or micromanaging daily governance, the essential balance of power is disrupted, leading to institutional friction. This overstep introduces severe systemic and democratic risks through a chain reaction. First, we see judicial policy making, where unelected judges bypass the legislature to directly dictate complex administrative actions and civic policies. This inevitably triggers executive paralysis. Excessive judicial interference and the constant threat of contempt of court make public officials risk-averse, stalling the execution of routine government work. Ultimately, this creates a dangerous democratic deficit. Accountability shifts away from elected representatives, who answer to voters, and places power in the hands of an unaccountable judiciary, disrupting the constitutional balance. The negative consequences also exact an economic and institutional toll, as shown on this collateral damage dashboard. First is the economic toll. Arbitrary, sudden judicial halts on major infrastructure and development projects, frequently on environmental grounds, can inadvertently drive up non-performing assets, or NPAs, in the banking sector. Second is institutional strain. An explosion of poorly vetted PILs has overwhelmed the judiciary, increasing the backlog and delaying regular, localized cases for ordinary citizens. Third is the publicity deficit. The legal system risks being misused by frivolous or politically motivated lawsuits, filed primarily for personal publicity rather than genuine justice. To see this tension clearly, let's map the areas of institutional friction, starting with the legislature. Amending power. While Article 368 gives Parliament the power to amend the Constitution, the judiciary developed the unwritten, basic structure doctrine, to place permanent restrictions on those amendment powers. Judicial appointments. While Article 124 outlines clear executive and legislative roles in selecting judges, the judiciary created the collegium system, a self-appointed appointment loop not found in the original text of the Constitution. Internal procedures. Though the internal procedures of legislative assemblies are constitutionally sovereign and protected, courts have stepped in to directly order flow tests and mandate live video broadcasts of proceedings, such as in the Jharkhand Assembly. The judiciary has also stepped into the executive domain through binding directives across 5 key areas. In resource allocation, the court issued mass cancellations of 2G spectrum licenses and executive coal block allocations. In law or order, it has bypassed standard executive hierarchies to issue direct, independent investigation instructions to the Central Bureau of Investigation, CBI. Regarding state appointments, the court stepped into executive privilege to directly appoint the Lokayukt in Uttar Pradesh. In civic policy, it bypassed local civic bodies to implement and enforce the firecracker ban in Delhi. Finally, in commercial regulation, the judiciary effectively drafted commercial zoning laws by banning the sale of alcohol within 500 meters of national highways. How do we resolve this tension? The answer lies in finding the Goldilocks Zone of justice. If government functionality is low, we see democratic failure or a need for necessary activism, where PILs step in to fill the gap. But if government functionality is high and judicial intervention remains overly aggressive, it causes policy paralysis and overreach. The ideal balance is the Goldilocks zone, a state of high executive and legislative functionality paired with restrained judicial intervention. In this zone, the government functions efficiently, and the courts step in strictly to protect fundamental rights. As our blueprint reminds us, judicial activism remains an essential safety net for social justice, but institutional restraint is the bedrock of a stable, functioning democracy. Don't forget to subscribe, like, share, comment if you enjoyed this quick revision.